All right. Well, thank you so much, panelists, for being here. Professor Rahdert, Professor Moreland, and Mr. Shapiro. Welcome everyone to our event. My name is Lorenzo Raboni, and I'm the president of Temple Law Federalist Society. I wanted to thank you for joining Temple and Villanova Law Federalist Society chapters tonight for our event, focusing on the next term of the United States Supreme Court, as well as the last term stats and trends. Before I introduce our esteemed panel for tonight's discussion, I wanted to open up with, for those of you in the audience who are not familiar with Federalist Society, the Federalist Society is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. The society seeks both to promote an awareness of these principles and to further their application through its activities. If you would like to join the Federalist Society, reach out to myself or Mr. Marchini, the co-president of Villanova Federalist Society, for more information. Without further ado, Mr. Marchini and I will introduce the panel. Ilya Shapiro is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. Mr. Shapiro is the author of the new release. Excuse me, Mr. Shapiro, I missed the name of the release. What's your new release, sir?
It's Supreme Disorder, Judicial Nominations in the Politics of America's Highest Court.
Yes, sir. Thank you so much. As well as the co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution, and editor of 11 volumes of the Cato Supreme Court Review. Mr. Shapiro has testified before Congress and state legislatures and has filed more than 300 amicus curiae briefs in the Supreme Court, including one that the Green Bag selected for its exemplary legal writing collection. Before entering private practice, Shapiro clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. He holds a BA from Princeton University, a MSc from London School of Economics, and a JD from the University of Chicago Law School, where he became a Tony Patino Fellow. And next is Professor Mark Rahdert. It is my pleasure to introduce my very own constitutional law professor, Mark Rahdert. Professor Mark Rahdert specializes in the areas of constitutional law, torts, and comparative constitutional law. Professor Rahdert is an award-winning author of scholarly books and articles and is a frequent public speaker and panelist, both nationally and internationally. He also has published commentary in such periodicals as the National Law Journal, the ABA Journal, and the Chronicle of Higher Education. Prior to joining the Temple Law faculty, he was a law clerk to Associate Justice Harry A. Blackmun of the United States Supreme Court and Judge Murray I. Griffin of the United States Court of Appeals for the Second Circuit. He also practiced law at the Philadelphia firm of Deckert, Price, and Rhodes. He is a graduate of Yale Law School, where he was a note editor for the Yale Law Journal, and a summa cum laude graduate of Harvard University. In addition to constitutional law, comparative constitutional law, and torts, his teaching interests have included political and civil rights, federal jurisdiction, freedom of religion, the Supreme Court, product liability, insurance, and federal American Indian law. Now I'll turn it over to Mr. Marchini to introduce his professor.
Thanks, Lorenzo. I'd like to introduce Professor Michael Moreland. Michael Moreland is University Professor of Law and Religion and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova University. He joined the Villanova faculty in 2006 and served as Vice Dean from 2012 to 2015. His areas of teaching and research are torts, law and religion, constitutional law, and bioethics. He received his BA in philosophy from the University of Notre Dame, his master's and PhD in theological ethics from Boston College, and his JD from the University of Michigan Law School. Following law school, Professor Moreland clerked for the Honorable Paul J. Kelly Jr. of the U.S. Court of Appeals for the 10th Circuit, and he was an associate at Williams & Connolly, LLP in Washington, D.C., and served as Associate Director for Domestic Policy at the White House under President George W. Bush. Thank you, Professor Moreland, for being here today.
Thank you for having me.
Yes, sir. Thank you so much. There will be time for Q&A at the end, and we're going to start off with discussing last term stats and trends. Mr. Shapiro, would you like to begin?
Sure. Well, thanks very much for having me. I put the link to my book in the chat there, although I was a poor law student, so please don't take this as any pressure, but just so you know what exactly the book is about, and you can ask your parents for a Christmas gift or something like that. This is the year it really became the Roberts Court. Chief Justice John Roberts presided over Donald Trump's impeachment trial. Remember that? It's like a lifetime ago, right? He navigated the court through unusual pandemic-driven telephonic oral arguments, complete with toilet flushes and forgetting to unmute yourself. The justices, they're just like us. And he was in the majority more than anyone else, including 12 of the 13 5-4 decisions. Perhaps most notably, he shocked court watchers by joining the liberals on 3 key cases involving LGBT rights, DACA, and abortion. That, plus Justice Neil Gorsuch's writing the opinion in the Title VII sexual orientation gender identity case, Bostock versus Clayton County, set off kind of a circular firing squad on the right as so-called common good constitutionalists went after originalists and textualists. But actually, when you look at the numbers, it was a pretty good term for conservatives. Of the 13 5-4 decisions, 9 had the conservative justices together, and only 3 had a conservative defect to join the progressives. Compare that to the previous term, when there were 8 5-4 cases where a conservative justice joined the liberals and only 7 where conservatives stuck together. Now, losses in big, high-profile cases sting, to be sure, but this is by no means a liberal court, which is why progressives breathed a sigh of relief, but aren't treating Roberts as the second coming of Anthony Kennedy, let alone David Souter. The term had 53 signed opinions, which is the lowest in over a century. You actually have to go back to the Civil War to find a lower number. And this production decrease was, of course, caused by the cancellation of the March and April sittings and shifting a dozen cases into this term that just started today. The court's 10 arguments in May were the first since 1997 that the court heard arguments that month, and the most May arguments since 1961. And of course, the delayed calendar pushed opinion releases into the second week of July. Altogether, the court released 7 signed and 2 per curiam unsigned opinions in July. The last time the court issued a signed opinion in July was 1996, and the last time it released 9 was in 1986. But back to John Roberts. He was in the majority in 97% of the term's cases, 58 out of 60. The only other justice who participated in at least 50 cases in a term and was in the majority that much since Roberts joined the court in 2005 was Justice Anthony Kennedy, who did it 3 times. Before Kennedy, the most recent justice to be in the majority in at least 97% of the cases was Bill Brennan in 1968-69. The last Chief Justice was Fred Vinson in October term 1949. Now, Roberts isn't a true swing vote, even though this term he went with progressives in 5-4 rulings more than any other conservative, but that was only twice, plus Gorsuch once. Instead, you can think of Roberts as the anchor or steering justice because of his tendency to vote in the court's majority. As for the others, Kavanaugh was in the majority in all but 4 cases, Gorsuch in all but 7, 89%, and nobody else was over 80%. Justice Thomas was least in the majority, just 72%, and only 55% if you don't include the unanimous opinions. In those 5-4 cases, as I mentioned, Roberts was on the winning side in all but 1 of the 13, Gorsuch in all but 2, Kavanaugh in all but 3. Ginsburg and Breyer were only in the majority 3 times each. So in other words, this was a centrist-driven court. Now, not surprisingly, Roberts and Kavanaugh were also the justices most likely to agree, 93% of the time, followed by Ginsburg and Breyer, Alito, and Thomas at 92%, and Breyer at Kagan at 90%, and nobody else was over 90. Not surprisingly, the lowest rate of agreement were between Sotomayor and Thomas, and Sotomayor and Alito, less than half the time. And we're again seeing stark doctrinal differences, as much among the conservatives as between them and the liberals, because only 36% of the decisions were unanimous. That's actually low. It's the lowest in about 12 years. The average for the last decade has been just under 50%, and that's ranged from about 40 to 60. The court reversed or vacated 2/3 of the cases it heard, which is a bit lower than recent trends. The Ninth Circuit attained a 1 in 9 record, 90% reversal, keeping its crown as the biggest loser. But really, wherever your appeal originates, getting the court to take your case is most of the battle. My final statistics are more whimsical about the number of questions asked at oral argument. Yes, people keep track of this sort of thing. Justice Sotomayor has solidified her title as the most frequent interlocutor in the post-Scalia world. In pre-COVID time, she asked 21 questions per argument. On the phone, she used the most amount of time, although not the most words per turn or words per second. That was the fast-talking Kagan. Justice Ginsburg maintained her run as the first interrogator in the regular arguments. Just under half the time, she was the first one to ask a question. And Justice Thomas asked his fair share of questions during the telephonic arguments. That is, again, once they had the telephonic, the remote arguments, they asked questions one after another rather than all jumping in a free-for-all. And so Justice Thomas, going second by seniority after the chief, asked his fair share of questions, and very important ones at that, showing that his complaints about the normal arguments are sincere and that he really doesn't ask questions then because he says his colleagues get involved too much and it's not a very useful process. So I'll leave the stats and trends there. If you want to ask me about any particular case from last term, happy to talk about it. And I think the professors might want to mention one or two cases now.
Professor Moreland, would you like to discuss a little bit about last term's religious cases?
Federal Society chapters for convening us. I do want to say a word, of course, about the events of the last couple of weeks and acknowledge the passing of Justice Ginsburg, of course, and her legacy. And again, we can talk if people have particular questions. As someone sort of more conservative, I had disagreements with Justice Ginsburg, not that she cared, on sort of big constitutional questions, but she was a great judge in every respect, and in particular, I think had an impressive body of work in areas like civil procedure and things that kind of fall under the radar, and was a exemplary, clear writer on the court as well. And so I think to keep her legacy in mind as we talk about this last term in which she was a member of the court. So the court, it was actually for those of us who are interested in questions of First Amendment law, it was an interesting term. The court actually didn't really, there's some free speech issues around the margins of some cases they decided, but it was a blockbuster term for religious freedom. The court handed down 3 cases. I'll just summarize them very quickly, and then again, if people are interested, we can talk about them in more detail. Kind of in descending order of, I guess, kind of long-term significance. The first was Espinoza versus Montana, which involved a tax credit scholarship program that was, though by virtue of a provision in the Montana Constitution, could not go to religious schools, although could go to other kinds of private schools. This is a so-called Blaine Amendment, or state-level Blaine Amendment, prohibiting state funding of religious schools. And the court, in a 5-4 decision with the 5 conservatives joining together in an opinion by Chief Justice Roberts, held that provision of the Montana Constitution, that these kinds of singling out of religious uses for public funds in these regards, that's unconstitutional. And so this will have, I think, long-term important implications for the availability of public funding for religious institutions, and particularly the point that religious institutions can't be subject to kind of disfavored discriminatory treatment. And then in a case involving the so-called ministerial exception, following on the court's decision 8 years ago in Hosanna Tabor versus EEOC, the court, in a pair of cases this last term, coming out of Southern California, held that teachers in a Catholic parochial school setting who had been subject to employment dismissals, that those claims are barred by the First Amendment from civil courts adjudication. It was a 7-2 opinion written by Justice Alito, clearly endorsing a kind of concept of church autonomy, not an unlimited principle to be sure, but an idea that with regard to internal self-governance and employment decisions for those who hold important religious functions within an institution, that these claims are immune from anti-discrimination law. And then finally, a case actually arising right here in Pennsylvania, Little Sisters of the Poor versus Pennsylvania. This is the latest iteration of the Jarndyce versus Jarndyce saga of the litigation over the Affordable Care Act's contraceptive mandate. In this iteration, because the Trump administration had issued a regulation that broadly exempted religious employers like the Little Sisters of the Poor from the provisions of this requirement, that this was challenged by some states led by Pennsylvania and New Jersey, arguing that, I mean, it's a complicated kind of administrative law issue, but basically that because the Affordable Care Act doesn't expressly provide for the creation of these exemptions, that the agency sort of acted outside the bounds of what the statute permitted by crafting these exemptions for them. And in a 7-2 decision, with the conservatives joined by Justices Kagan and Breyer, as Kagan and Breyer also joined the ministerial exception decision, the court held that this rulemaking by Health and Human Services was permissible as a matter of administrative law. I think some of us on this side of the issue also think that such exemptions are required under the Religious Freedom Restoration Act as well, although the majority opinion by Justice Thomas kind of set that issue aside, at least for now. But in that regard, all three decisions came out in, again, from my standpoint, a kind of pro-religious freedom standpoint, a strong endorsement of that. And in a way, I'll just kind of end with this. As I've taken to saying, and people like Mark Renzi, the president of the Beckett Fund that litigates a lot of these cases, have said, it's a kind of effort, however intentional or not, on the one hand to allow for lots of kinds of civil liberties in certain contexts, especially in the light of a case like Bostock involving LGBT discrimination. And on the other hand, also an endorsement by the court of kind of broad space for religious freedom as well, as a way of kind of trying to navigate a truce in the culture wars. Again, how purposeful that is, I think that's debatable, but that was, I think, one of the important takeaways from the last term.
If any of the panelists would like to say anything on that, then this would be the time. If not,
I'll just say real quick, Espinoza might be the longest lasting, or having the biggest impact of those cases potentially, because I think it removes the last, at least federal law, obstacle to school choice programs. I mean, there are still things that might be litigated and are being litigated according to state constitutional law. But at the otherwise, I think this has become almost entirely a political issue, a policy issue, and yeah. And also, what's interesting about those religion cases is that they came a few weeks after I mentioned Gorsuch's opinion in the Bostock case, reading the prohibition on discrimination based on sex in employment law, the Civil Rights Act of 1964, to also cover sexual orientation and gender identity. After that case, there are huge concerns about whether, Gorsuch is no longer going to be protecting religious liberty, and Roberts and all that. And well, Gorsuch not only was in the majority in all of these cases, as was Roberts, but Gorsuch specifically, joining with Alito and with Thomas, depending on the case, would have gone even further. So I think it's too simplistic to read anything into any one particular case.
Okay, thank you so much. Next, we're going to talk about some upcoming cases. Fulton v. Philadelphia, California v. Texas, and Kearney v. Adams. And if there are any others that you would like to discuss, please go ahead. Professor Moreland, would you like to start with Fulton v. Philadelphia?
Sure. I don't know, does Professor Rahdert want to say anything about last term before we move on to the next term? I just wanted to.
Well, let me just throw in one thing, one additional case, or actually a pair of cases that I think are important emerging from the term. And
Professor Rahdert, can you unmute for us? Sorry about that.
I thought I had. So my apologies. I just wanted to throw in one additional set of cases from last term that I think are important to note. And those are the cases Trump versus Vance and Trump versus Mazars that were involved the issue of whether the president of the United States is subject to investigation by Congress in one case and by a state district attorney in another for possible criminal violations. And what's important about those cases, I think, is that the court rejected a claim that the president is absolutely immune during his presidency from investigation. A solid, if you count all the different opinions that agree to this, that I think 7-justice majority was pretty clearly in that space, and that the court did it in such a way that the issues will not be resolved until after the November election, either in either instance. And the court did recognize some potential limitations on, excuse me, something seems to have happened here. Am I still with you?
You are, Professor.
Okay, for some reason my feed has gone dead.
We can hear you and see you, sir.
Okay, terrific. Well, what I think is important from that case is that the president is not above the law. The president is subject to the law. The president can be investigated for possible criminal violations. He can be investigated by Congress. There are limits that the court imposed, particularly on the congressional investigations regarding a need for greater particularity and justification for the investigations that take place. But I think those are significant steps that are of a piece with the Clinton versus Jones case in the 1990s and the Nixon versus United States case in the 1970s, establishing that the president is in fact subject to the law, and that the needs, particularly of criminal investigations, can override claims of executive privilege, at least in some circumstances.
Thank you very much, Professor. Professor Moreland or Mr. Shapiro?
Well, I guess I'll say something about Fulton, which we were going to talk about next, I guess. So I think for First Amendment purposes, probably the most important case that the court has agreed to hear so far this coming term is Fulton versus Philadelphia, so appropriate for a panel sponsored by the Villanova Temple. This is a case involving a decision by the city of Philadelphia to no longer license Catholic social services in the city of Philadelphia from providing adoption services on account of Catholic social services refusal to place foster children with same-sex couples. And so it's a collision or intersection once again of questions about anti-discrimination law on the one hand and rights of religious freedom on the other. There are kind of a couple interesting things about the case. One is that the record in the case has some sort of bad facts for the city of Philadelphia, kind of shifting justifications for the policy and selective enforcement of the policy, so that it could end up as a kind of masterpiece cake shop too. That is to say, a case that would be narrowly resolved by the court on the grounds that the kind of decision-making process whereby Catholic social services was excluded from a license has some kind of animosity to it. The more interesting issue is that there is a question presented in the case about whether the court should revisit Employment Division versus Smith, the 1990 watershed free exercise case that held that with regard to laws that are neutral and generally applicable, there's no constitutional right of religious free exercise exemption. And so the court, there's been some interest, actually somewhat on the left and more increasingly on the right, in revisiting Smith and of maybe heightening the level of scrutiny to which free exercise claims are subject. And so we'll see. It could be, as I said, it could be a very narrow decision. It could be a very broad decision revisiting Employment Division versus Smith writ large, or of course the city could prevail. But that's an important one to keep an eye on, and oral argument is actually scheduled for the first week of November.
Yeah, that's in that case. I doubt they'll go whole hog and overturn employment division. It sounds like it's ripe for masterpiece cake shop all over again, finding animus with what Philadelphia did or singling out religion for what have you. But we'll see. Both sides seem to deny the idea that the Catholic Social Services is a government agency, and if that's the case, then yeah, it leaves even less wiggle room for Philadelphia, I think. Let me discuss the case that was the first one of the term that was just argued this morning. Carryover from last term, one of those that was bumped due to the pandemic. This is Kearney versus Adams, and it's from neighboring Delaware for all of you. Delaware is, I learned this morning at argument, I hadn't remembered this from reading the briefs because I actually did file a brief, which I'll get to in a second, is the only state in the country that has a rule that members of the top 3 courts in the country, so the Supreme Court, the Chancery Court, very important in Delaware as a commercial law hub, and one other, have to be, first of all, members of a major political party, Democrats and Republicans, but also there can be no more than a bare majority from any major political party on those 3 highest court. So along comes Mr. Adams, who was a Democrat, but decided that the Democrats had become too centrist or too moderate. He's kind of more of a Bernie or a Green kind of independent. He's an independent for purposes of this lawsuit. And he challenged this on First Amendment grounds, freedom of association, freedom of speech. Why, to be a judge, or at least in these top courts, do I have to join one of the majority parties? And ultimately, the Third Circuit invalidated this provision of the Delaware Constitution, focusing on the other major political party part, and because of principles of severability, taking with it the bare majority requirement. I filed a brief, Cato filed a brief alongside First Amendment scholar Eugene Volokh, taking aim purely at the major political party prong. That is, if you're an independent, if you're a Green, a socialist, a libertarian, then you're effectively not eligible for these positions. The bare majority, I mean, whatever you might think of severability analysis, I doubt the court will end up touching that part of it, because there are several federal agencies that have a similar, either equally balanced or bare majority requirement, whether the Federal Election Commission, the Securities and Exchange Commission, and others. And I don't think they want to open a whole Pandora's box with there. But the idea that certainly what I got from this morning's argument was that many justices are uncomfortable with the idea that you have to join one of the major political parties. Of course, another concern, and this is a question that was added by the court itself after taking this case, was there was concern about Mr. Adams's standing. That is, has he actually applied and been rejected? He says he's considering applying for one of these courts. Is that enough? And it could be that if at least 5 justices don't want to wade into the First Amendment thicket for this rule that, as I said, only exists in Delaware for the purpose of their courts, then they have that off-ramp of standing. It could well be, but it didn't sound like this is an ideological type of case. Indeed, you can see that in the filings. Both the Democratic National Committee and the Republican National Committee filed on one side, supporting Delaware and its rule. Not surprisingly, the Libertarian National Committee filed on the other side. So we'll see what happens there. But it was an interesting argument that, unfortunately, at least for me, who's more interested in the First Amendment issues, spent a lot of time on standing.
Professor Rahdert, do you have any cases of interest you'd like to discuss, or do you have any comments on Mr. Shapiro's?
Am I on?
I can hear you and see you, sir.
Am I unmuted?
I believe so, sir. Yes.
Okay, terrific. I just wanted to say, oh dear, I'm getting a feedback here. It's going to make it difficult for me to talk. But I just wanted to say that on that particular case, I find the potential standing issue to be a fairly significant one. So be interesting to see how that is out.
If you have earphones, that cuts back on the feedback.
All right.
Sorry, yeah, we're all this is our first Zoom event as well for the year, so we appreciate all the panelists and your patience with us as well as the attendees. We can either, it's up to the panel, discuss California v. Texas, or we can move on to a few questions about the 8-member Supreme Court and possible
so California versus Texas is the Obamacare case, and that would be a good segue to the 8-justice court or the nomination of Judge Barrett, because a lot of the discussion has been the consequence of Justice Ginsburg's passing and the possible confirmation of Amy Coney Barrett to the Obamacare case. So this, in this case, the issue is whether whether the individual mandate is constitutional, and if not, how much of the rest of the law has to fall. Now you're thinking, maybe you're not because you haven't gotten there in constitutional law yet, but you're thinking, didn't the court decide that 8 years ago? There's a case called NFIB versus Sebelius, right? Remember, I mean, John Roberts famously called the individual mandate a tax and therefore upheld it under the taxing power after saying it wasn't justified under the Commerce Clause, Necessary and Proper Clause. So what are we doing? Is this like a second bite at the apple? And the answer is no, because in 2017, Congress zeroed out the penalty, tax, whatever you want to call it, that someone had to pay if they did not purchase an Obamacare complying health insurance policy. Well, what does that mean? It seems to mean, and this is what the lower courts have held, the district court in Texas and the Fifth Circuit, that Roberts's taxing power saving construction is no longer available. Okay, but what does that mean for the rest? Because Congress, unlike in 2012, when the court was engaging in this severability analysis, that is, again, I'm using this term, it comes up in a lot of big cases. If part of a big law, big statute is found unconstitutional, does the whole statute have to fall, or can you carve it out? And there's basically standards that the court applies, prudential standards, about what of the remaining statute would Congress have left in place, what is inextricably connected and has to fall with it. So here, there's a lot of discussion of, is the mandate tied to the pre-existing conditions, protections, other minimum coverage requirements? And the thing is, when Congress zeroed out that penalty tax thing in 2017, it did not remove anything else from Obamacare. And so we have direct evidence what Congress would have left standing did it not have the mandate there, unlike in 2012. So it's highly unlikely that there are any votes, let alone already 4, plus the potential Barrett, to invalidate the ACA in its entirety. There are some nuanced arguments to be made. I filed a brief supporting the individual plaintiffs. That is, it's not just the states, Texas and some other states, that are suing. But there are individual plaintiffs who are buying policies on the off-exchange individual market. Okay, so this is not affordablecareact.gov or obamacare.gov. This is not your employer healthcare plan. Most of us who have health insurance get it through our employer. It's not that kind of group health plan, but it's the individual market, not on an exchange. And they say that they're harmed in various ways. Well, my brief with Josh Blackman on behalf of Cato says, well, why doesn't the court craft a narrow remedy, just cutting out some of the attached regulations and therefore making the policies cheaper for the individuals buying on off-exchange markets? Maybe it's a prudential kind of argument, but I don't think that this is an existential threat to the Affordable Care Act like the 2012 case was.
Yeah, and I'll just add, there's some interesting divisions in the court that we'll see about this issue that Ilya raised about severability. And for those who are really interested in that, if you're taking Fed courts now or similar courses, the decision in the robocall case from this last term, in which Justice Kavanaugh for the court held that a provision of this robocall prohibition statute was unconstitutional because of a difference in treatment of different kinds of telemarketers, but that provision could be severed without the whole statute being struck down. And so it'll be interesting to see kind of how, if they reach that question, kind of how the justices divide on that issue.
A similar issue is in a case called the Collins versus Mnuchin, which is about the federal housing. Gosh, the FHFA. I forget what the alphabet agency stands for, but anyway, it's a follow-up to a challenge to the Consumer Financial Protection Bureau, the CFPB, this term, where the single director structure was held to violate the separation of powers, but the remedy was just to change that structure, not strike down the agency. And similar issues going on with the remedy in the separation of powers case there. Mark, you're muted.
Let's see. Unfortunately, Professor, you're still muted, and we can try to see if the host, Andrew, can fix that for you.
It could be the way that you plugged in your earbuds. Okay, so well, Lorenzo, should we quickly touch?
I'm sorry.
No, should we touch on the Eighth Justice Court and the vacancy and whatnot before opening for questions?
Yes, absolutely. So I just wanted to pose this question. Once Professor Rahdert, and I apologize, Professor, we'll get you in the text box to make sure to see if we can get you back up and running. We just wanted to ask the panel, so there have been even numbers on the court before. If the Senate does not approve a ninth justice in time for the presidential election and any possible litigation, we just wanted to get the panel's take on how that might impact any litigation. And then also, is it unlikely or likely that Donald Trump's Supreme Court picks would recuse themselves from such a event, from such a case?
Well, we had a 4-4 court 4 years ago. And so we answered this question, and it's not unusual for the court to be shorthanded every now and again, whether due to deaths like this or in 2016 or recusals or what have you. And generally the court tries to avoid deciding cases 4-4. What that means is an affirmance of the lower court without any opinion or without any precedential weight. They typically try to hold those cases over for when there is a ninth justice, or sometimes they dismiss them. But after Scalia's death, only 4 cases ended up being decided 4-4. A lot of others, the court strove mightily to have more narrow decisions than they otherwise might have been if there was a full 9-justice court. But everyone's nightmare scenario of an election-related case, right? We don't know who's won. There's challenges to key swing states and how they count the ballots and all this, and it goes to the court, which is 8 justices. And under this scenario, Roberts would join the liberals and it becomes 4-4 that way. Well, this is not a constitutional crisis. All that means is that the lower court's decision would stand. So if, let's say it's Pennsylvania, a swing state, if that's the litigation that reaches the Supreme Court, well, the court deadlocks, then whatever the Third Circuit said is that goes. And I'm not sure whether the loser or the supporters of the losing candidate in that scenario would view the Third Circuit finality any less legitimately than a 5-4 loss at the Supreme Court. So, you know, it's not good for the atmospherics for the country as a whole, but it's not a constitutional crisis.
Thank you. Professor Moreland, Professor Rahdert, before you say anything, Professor Rahdert, you might have the best luck, I'm being told, if you disconnect entirely and then rejoin us so that you can be here for the Q&A. Yeah, unfortunately, we can't hear you, so I think you might have the best luck disconnecting, and then if you type in the chat box, then we can I can help you, sir. And Professor Moreland, do you have anything on that, the possibility during election litigation that there might be an 8-member Supreme Court?
Well, I mean, I think that, as Ilya says, obviously the straightforward doctrine on that point would be that the lower court decision would stand. I do think there would be tremendous pressure on the court not to divide 4-4 or not even to divide 5-3 in that kind of partisan fashion. I think that there would understandably be concerns, especially given whatever happens the next few weeks with Judge Barrett's nomination, but then the questions being raised about potential jurisdiction stripping or court packing. I think that there would be a real reluctance to amid all that, to kind of have the courts, the Supreme Court's legitimacy itself kind of front and center in that kind of dispute. How that would actually be navigated and what the cases would actually look like, who knows?
Thank you very much. And yeah, we're trying to reconnect Professor Rahdert. He's going to try to reconnect. But until then, to all the attendees, unless there's any more from Mr. Shapiro or Professor Moreland, to all the attendees, if you raise your hand in the chat, our technical host, Andrew, will unmute you and you can ask a question to the panel. So while you guys are doing that,
I'll say one more thing while people unfreeze their brains and start typing and whatnot. So regardless of what you might think about the propriety of the Republicans now confirming a nominee so close to the election in the abstract, or 4 years after, of course, holding the Garland seat open, historically, as a matter of statistics, the biggest determinant of whether a nominee gets confirmed is whether the same party controls the Senate and the White House. This might seem like an obvious thing, but it's it's quite stark. Even forget election year ones, just overall, when it's united government, the confirmation rate is about 90%, and when it's divided, it's under 60%. And that becomes even a bigger difference in presidential election years. 17 of 19 times when there's been an election year vacancy arising, during united government, there's been a confirmation, and during divided government, it's been 2 of 10, or actually one of those 2 is after the election. So before the election, only 1 of 10. Again, knowing nothing else about the political moment or who was running either in 2016 or 2020, that gives a lot of the answer, just because politics has always played a role in these sorts of things.
Professor Rahdert, you're back. Do you have any thoughts on election litigation in November and an 8-member Supreme Court if the Senate fails to nominate? Or yeah. I would try to just take out the earphones. Now that you're back on, there's only one of you on the screen. I think you'll be able to hear and speak if you just unplug the earphones. Thank you guys all for holding it for a second. I guess, Professor Rahdert, yeah, I'm so sorry. Oh, here we go. I heard you.
Can you hear me?
Yes, sir. Thank you so much.
All right. Thank you very much. Well, I think what we have to recognize is that the situation here is one in which kind of no matter what, there will be a new justice on the Supreme Court, and it will be Justice Barrett, barring unforeseen circumstances that we can't predict. Whether she'll be confirmed before the election or after the election, I can't say, but she will be confirmed. It's the culmination of Mitch McConnell's quest to pack the court with conservatives, and he's not going to stop until he does. So we just have to anticipate that that's going to be the case. And I think it's useful to look forward and say, well, what kind of court are we going to have? And I think there's some things we can definitely say about the court that we're going to get. I want to start by saying I don't think that conservative justices or liberal justices are monolithic. They have variations in intensity and commitment to various causes and in time periods when the court is heavily appointed by Democratic presidents or heavily appointed by Republican presidents. We see divisions, we see differences, we see unexpected developments, partly I think because it's really not that easy to anticipate what the big issues are going to be in even the relatively near future. A fun experiment you can do with yourself is to write down on a piece of paper what you think are going to be the 5 biggest issues before the Supreme Court in 5 years, and what the 5 biggest issues are going to be in the Supreme Court in 10 years, and then put that away someplace where you can't open it until 5 years later and 10 years later, and see how right you were. And I'll bet you missed it completely, because times change and issues change. But this is a revisionist court. It's going to be a revisionist court. It's going to revise the law. Where is it going to revise the law? First of all, I think it's fair to say that federal constitutional protection for reproductive rights is largely going to come to an end. Roe versus Wade will be overruled. Casey, which is really the law, will be overruled. Whether that happens step by step, in a few steps, or in one major blockbuster decision remains to be seen, but it will happen. I think federal constitutional permission for race-sensitive college admissions is likely to be sharply curtailed, if not eliminated. There are probably enough justices on the court to do that right now. They just haven't gotten the right case, but that will happen. What I think is interesting there is the question of whether the efforts of the Trump administration are also followed by this new court, making it impossible not only for government public universities like Temple to consider race in their admissions, but also making it impossible for private institutions to do so as long as they receive federal funds. And of course, no college or hardly any college or university can survive in today's world without federal funding. I think another area, and we've already talked about it a lot because there's already been a lot of movement, but there will be more with respect to the religion clauses of the Constitution. And we are in the transition right now from a principle of separation of church and state to a principle of integration of church and state. The interesting question for me there will be, so far the court has dealt with this largely in the context of institutional religion, widely recognized and widely practices religion. What about fringe religions? What about unusual religions? What about nonconformist religions? What about what the court had to struggle with back before it decided cases like Employment Division versus Smith, which is the claim of an exemption from government regulation by, to bring it in sort of an extreme case, the religion of me, the religion that I believe that nobody else does. Do I get the same breaks from the government and the same involvement with the government as the institutional religions do? Although I'm less confident about this, I think there's going to be a revisitation by the court to the constitutional contours of the administrative state. There are already justices on the court who are looking to try to cut back on the authority of administrative agencies and the independence of administrative agencies. I'll be curious to see whether that continues when the administrative agencies are, when the executive control over the administration, the administrative agencies is being implemented by progressive presidency and executive as opposed to a conservative one. Will the court apply those ideas of restraint across the board or not? I think that despite the manifest inequities and maladministration that surrounds the issue, the death penalty is likely to remain a constitutional form of punishment in this country for at least another generation with the current and future population of the court. And I think that the court's new practice of micromanaging judicial administration of preliminary injunctive relief in ongoing cases is likely to continue. That's another area in which I'd like to see how that plays out in terms of political valences. And finally, I think it's fair to say that politically motivated legislative and administrative measures to dilute, deter, and suppress voting will continue to get a free pass from the federal judiciary, just as it has been for the last several years under the Roberts Court. But I think the biggest issue that we need to face in terms of looking at the future is what's going to happen in the case that's not yet on the docket, but may well arise, the case of Trump versus Biden, or whatever it ends up being called. There are lots of signals currently out there that the Republican Party is setting up to challenge the results of the election if President Trump loses, and to set up a Supreme Court contest and ask the Supreme Court to do what it did in 2000 in Bush versus Gore, which is by a vote of 5 votes to override the results of the popular election in terms of electoral pluralities or majorities. How will the new Roberts Court, the revisionist court, respond in that situation? I take some encouraging but fairly cautious signs in the treatment last term in Trump versus Vance and Trump versus Mazars. This is a court that, at least in its configuration in July, was not prepared to give the Trump administration all that it wanted. But I worry about what lies ahead if the court is asked once again to use the context of a legal dispute to decide judicially the outcome of the presidential election. It's possible, although I think it's not desirable and I think it's not consistent with the constitutional plan. It's possible for the nation, I think, to survive the court doing that maybe once a century. But doing it once every 20 years, if we continue to do it, if decisions get rendered by the court rather than by the people as to who is elected president, I think that we become a pretend democracy. And I think we're at risk of having our democratic system begin to decay, no matter what the individual arguments are in the individual case. However, they're formatted. If courts rather than people decide presidential elections, we're not a democracy anymore, in my opinion. So those, I think, are the big issues that we need to worry about and to anticipate going forward.
I actually agree with a lot of that, and I'm happier about that development than Professor Rahdert, of course. But a couple of tweaks, the whole rhetoric about dilution or deterrence or suppression of voting, I think that's a canard. I think our Voting Rights Act is fully functional with Section 2 and Section 3 cases. We can discuss Shelby County. I've written all about that, but I think that is. Just like a lot of right-wing activists talk about voter fraud, it's just it's a red herring. On abortion, I think we're likely to have, at least in the short term, regulations and restrictions that otherwise were struck down, as in this past term in the June medical case, will now be upheld. And in effect, that means that whether explicitly or not, Casey would be overturned, or the dead letter, the undue burden standard, which was for so long was basically just a restriction that gave Tony Kennedy a headache. That's what undue burden meant. And now it'll revert, ironically, to Roe, where it was kind of a sliding scale, where restrictions in the first trimester were not permitted, in the third trimester they were, and otherwise it's kind of viability and kind of a unclear exactly, but the effect is to really go back to the Roe standard rather than this Casey hand waving. On the integration of church and state, I'm not sure exactly what that means. Instead, what we seem to be happening is, and especially by Gorsuch, and this is why I like Gorsuch so much, is that you respect both LGBT rights and religious rights. I think Utah came up with an accommodation. It's called the Utah Compromise, where you do that sort of thing. And as the only lawyer in the country to have signed briefs supporting both Jim Obergefell and Jack Phillips in Masterpiece Cake Shop. I'm sorry, Cato is the only organization. I think there were two other lawyers, Doug Laycock and Professor Berg at St. Thomas in Minnesota. We were the only three lawyers they had different clients in that way. I think it's perfectly consistent to make a distinction between public and private action and respect the wider freedoms of all. But anyway, Lorenzo, I think, Mike, if you have more comments, that's great. Well, Lorenzo, we seem to have a few Q&As here.
Yes, sir. If the panelists are ready, we will start that. Our technical host will unmute the first Q&A.
Our first question is from Josh.
Oh, this is a typewritten question, right?
Yeah, sure. I can speak to it also. Yeah, it was
Go
just.
ahead. Yeah.
Can you hear me?
Yes.
Yeah, it was just on the severability argument. I think you guys were pretty uniform that even if the court sort of severs some principles of the ACA, that they're not going to strike it all down. I'm wondering if the ACA's functionality since the individual mandates repeal is sort of, I don't know the severability test, but it's sort of an argument to show that that the law is capable of functioning as is.
I think that's part of it, and part of it is equally or more important is that Congress had the chance to sever whatever it wanted to sever, and all it changed was zeroing out that penalty. But sure, functionality, whether a given a statute can work, we now have evidence that it can work. You might not agree with the way it's working and some of the consequences and whatnot, but I think that probably does go towards it. And there are, we saw as Michael said, Professor Moreland, the political consultants case, Barr versus AAPC from last term, showed that there's plenty of justices who would prefer to sever than to strike down laws wholesale.
Yeah, the basic division, and I don't claim great expertise on this, but the basic division in that case that appeared is that Justices Thomas and Gorsuch have some reservations about severability doctrine as it's evolved, and thinking that it involves too much kind of rewriting legislation, which is inconsistent with what courts should be doing. But in that, in the robocall case, you had plurality opinion by Justice Kavanaugh, joined by the Chief Justice and Justice Alito, and then also the progressive members, liberal members of the court, joining them on this severability issue. And so I think the broad consensus on the court, at least as signaled in that case, was, could be different considerations in the next one, is that as your question states, that if something like the pre-existing condition provision or the, say, coverage up to age 26, something probably of interest to many law students, that those provisions can be untouched by, say, whatever happens with the individual mandate, then the court would be inclined to sever that.
I'll just add that I think that the severability issue in the NFIB versus Sebelius case was an important divider point that sent Chief Justice Roberts on his journey, which led him to finally use the tax justification for the individual mandate. It has always struck me that there would be some implicit inconsistency in the position that says, well, the individual mandate isn't really a necessary and proper part of this enormous statute, and therefore it doesn't qualify under the necessary and proper clauses within Congress's power. And then to say it's so central to the statute that if it's gone, everything else has to go as well. So I'm inclined to agree that that severability is going to be a real sticking point in terms of the challenge to the entire fabric of the Affordable Care Act.
Andrew, we're ready for the next question.
Our next question is from Joe Hogan.
Thank you, guys. So I had written a question out. I just wanted to thank Cato, too, as a former Hill staffer. I attended a lot of briefings and had a lot of lunches there, so thank you for that. But my question was more about the Bostock opinion. I remember reading or seeing some thoughts going around that it was joined by Roberts to kind of have a more narrow opinion. I was just kind of seeing what everyone's thoughts were on that, as opposed to him being the Chief Justice, getting to choose who would write it, as opposed to maybe Ginsburg if he sided with the minority.
Yeah, I discount that kind of, it's all speculation. We don't know, and we can't know until, decades hence when we see the justice's papers. But I think he moved over probably to make it 6-3 rather than 5-4 and give some cover to Gorsuch, or at least not have another 5-4 divided politically controversial case. And I say that because if he hadn't moved over there and Ginsburg had been the assigning justice, I think she would have assigned it to Gorsuch as well, because he was clearly the controlling voice. If Ginsburg took it herself or assigned it to one of the other liberals, and they had gone on some frolic about how words change or the meaning of justice change 50 years after a statute was passed or what have you, then Gorsuch would not have joined that. And he would have still written his own separate opinion, and that would be considered the controlling opinion regardless. So I think there is strategery in what Roberts does and did in that case, but it's not exactly that kind.
I'm inclined to agree with that. It's an important part of the Chief Justice's role to try to figure out how to assign cases. And obviously, if the Chief Justice is not in a majority, it falls to the senior justice who is. But it's what I think a careful Chief Justice or Associate Justice does is to assign the opinion to the justice who is closest to the middle, but falling on the side of the majority. Because if that justice then prepares an opinion that that justice is comfortable with, everybody else in that majority is likely to be comfortable with it as well, and there will be a court. That's the what I have often called the rule of five. When you're working on creating an opinion, you want to at least get 5 votes. Actually, you'd prefer to get 6. You'd prefer to get 9 if you possibly could. But you hew as closely as possible to the narrowest scope of decision that will get you the votes that you need. And on a critical case like that, having Justice Gorsuch's vote as a kind of a surprise, not an expected outcome, he'd be the designated opinion writer almost no matter what.
Thank you very much. I know it's 6 o'clock. If the panel is okay with one more question, is that acceptable to the panel? Thank you so much. Andrew?
Let's go with Maximilian Santiago. Are you there?
Looks like
We heard a little bit.
Maximilian, we saw you for a second. If you unmute. We can go
I
to the
suppose
new
we
one.
can go to another question. Reed Truitt will answer his question.
Well, we kind of talked about that, about the divisions on.
Yeah, that's the severability in the ACA.
Oh,
There was an earlier question about Google versus Oracle, which is probably the biggest business case on the docket. And not being an intellectual property lawyer, I'm going to punt on that.
I'm not prepared to comment on that one either.
Okay.
That's going to be a lot of big law billable hours in that. Google versus Oracle. Yeah, that's a pricey one.
And our last question is, actually we have 2. From Anthony or Hannah. I think you can see the question, so it's up to you which one you'd like to answer.
Do you want to unmute?
The administrative, so Hannah Schroer asks about the administrative state. This is, I think, and something that people like Ilya, libertarians, have been very interested in for a while. I do think that, especially with an addition of Justice Barrett, that it'll be interesting to see kind of whether or not a more ongoing kind of deferential view to the administrative state. Interestingly, she clerked for Justice Scalia, who did tend to have a kind of deferential view toward administrative power, was more or less reconciled to the Chevron doctrine and things like that. But there has been effort, led, I guess, principally by Justice Gorsuch, to revisit those cases that create a kind of deferential view toward administrative regulation or statutory interpretation by agencies. And I think that will be one of the, as Mark Rahdert said earlier, I think that will be one of the big issues over the next few years. But there is this new book by Adrian Vermeule and Cass Sunstein that kind of continues the argument that folks on that side. And interesting there, you have someone like Cass Sunstein is a little more progressive, Adrian Vermeule more conservative, kind of arguing that there's a kind of inevitability to the rise of the administrative state, and that these, no offense, Ilya, but the kind of the efforts on the part of libertarians to kind of hold it in check are are always going to be very difficult to pull off. I'm not an administrative law person, so I don't really have a dog in the fight, but I do think that will be one of the really important areas to look at. And it's a kind of an issue that, doesn't get a lot of kind of, public attention, like abortion or something like that, but has potentially very big implications.
Just to add another point, in addition to the question of what kinds of directions and how much specificity Congress needs to give to administrative agencies in order for them to have authority, and how far they can go beyond what Congress dictates. There's also the issue of the role of administrative agency vis-a-vis the executive. There are several administrative agencies that have been deliberately set up by Congress to have a measure of independence from executive control. And there is a vein of objection to that is represented on the court, which says that no, if there's one executive, the president has to have ultimate control over all executive actors, and therefore the president should be able to dictate to these assertedly independent agencies how they must perform. So I think that will be an issue the court will have to wrestle with as well.
It's not just libertarian fever dreams. Kavanaugh and Gorsuch were in part selected because of their pushing back on the administrative state in different ways, whether in terms of cutting back the scope of deference or, as Kavanaugh would have it, and as Scalia also did towards the end of his career, to work harder, for judges to work harder, not to find, let alone manufacture, ambiguity in the statutes or regulations they're interpreting, such that the question of deferring to the agency comes into it in the first place. And I think both on non-delegation and on deference doctrines, there's already started, and there's going to be more of a shift. I mean, even the case that preserved our deference, which is deferring to agency reinterpretations of their own older regulations, where 2 terms ago in the Kaiser case, the court split 5-4 on whether to overturn it, but Justice Kagan's majority opinion, joined by Roberts, really changed what our deference is, and really it should be called Kaiser deference, to such an extent that Roberts, concurring in the majority, and Kavanaugh, concurring in the dissent, which Gorsuch wrote, said there's really not much difference between the majority and dissent. Anyway, that's getting a little bit into the weeds, but I do think, there's not going to be a complete overturning of Chevron. That's unlikely, but a pushback, holding the feet of bureaucrats to the constitutional fire. I think we are going to see moves in that direction. And there's no cases yet on the docket this term where that could happen. So that's all in the future.
Thank you. Excuse me. Sorry about that.
Can I just throw in one comment that just something Ilya just said? It refers to something people were talking about earlier when I had to leave and come back. One of the things that I think we'll see with this court right now is a certain caution about grants of certiorari in cases that might move in a different direction if a full complement of 9 justices was present. The court has a lot of techniques for sort of slowing down its decisional process on petitions for review. And in cases where it thinks there might be a 4th vote that's not there now, they're likely, I think, to hold on to those cases and not either deny them or grant them until they're at full 9 justices. We've seen them do this before. So there will be this period of caution in terms of cert grants until the court's fully staffed.
And I think one area where that's especially true is in the Second Amendment. The court, after District of Columbia versus Heller and McDonald versus Chicago, it's really not taken a case to kind of delineate the metes and bounds of what the Second Amendment right to bear arms looks like. And they turned down the chance last year to take one or more of those cases. But I do think with a full complement and maybe with the addition of an additional conservative, I think the time will be ripe to decide one of those cases.
Well, thank you very much to the panel. We wanted to give you our sincere thanks for being here today in this new atmosphere, trying things out. And I think it's really great for the students and for everyone who joined us, and wanted to thank the attendees as well. And I hope you guys all have a fantastic night and great week. And we will follow up with you. Thank you so much.
Yeah, thank you for coming out. We appreciated it.
Bye, everybody. Thanks.
Have a great night.